Welcome to Health Policy, Organization, and Finance. This is your Week 10 video. Last week, we talked about the underlying legal limitations on public health law. If we could make any rule we want, we could probably improve health outcomes quite a bit. However, we would be infringing upon those personal liberty interests talked about by the court if we created policy that invaded that personal liberty interest that is so very important, according to the court, in every single person. So why are we discussing this? It's important for public health professionals to think about who they are reaching out to when they try to influence health. What exactly are they impacting, and what's the reason? A good example is teen smoking. Teens are not supposed to smoke because it's illegal. But as public health professionals, we try to do a lot of interventions anyway. We don't just simply rely on the fact that smoking is illegal for teenagers. And that's important because we have to think about multidimensional interventions that also take into account the underlying legalities of public health. So this week we're going to read another case, so I'm going to do a quick case review. Many judicial decisions are written in a very formulaic way. So if you read the cases last week and felt like it was a lot of gobbledygook, that's okay. Cases are usually written in a specific way, which is it starts out with a summary and then goes into the background, and then they tackle the legal issues. After that, they talk about what is the current law and analogous cases or other like cases before they give a decision at the end. So if you think about these steps and you read a decision, you should be able to orient yourself based on these bullet points. This week we're reading state Supreme Court cases. I just wanted to give you a little snapshot of how courts work if you're not familiar with courts. So a lot of lower courts are called trial courts, and that's where original decisions are made. Intermediate courts, or sometimes courts of appeal, are where those decisions might be overturned. Now, if it gets up to a Supreme Court, which is the U.S. Federal Supreme Court, or each state has a state Supreme Court, what they're really doing there is trying to figure out an issue that hasn't been figured out before. So really what these Supreme Court's job is to define what the law is. A lot of times these courts aren't actually writing a decision to guide the original plaintiff and defendant, or whoever the case was about. These court decisions are to guide the judges in either the intermediate or appeal courts or the lower courts. So a lot of times these decisions are written in a way to inform other judges. So this week we continue talking about health decisions. Specifically this week, minor health decisions, or those folks under the age of majority, which most of the time is 18. Now, as we know, as a general rule, parental consent is required to treat children. So all those folks under 18, they can't form a contract, they can't go out and buy a car, they can't go get a credit card, and likewise, they really can't just tell the doctor what kind of healthcare decision they make. However, this isn't really that simple. So this week we're going to talk about some of the intricacies of minor health decisions. And as we do it, I want you to think about health decisions in general. Why do we make the policies we make about health decisions? So why is consent important legally? Well, consent in healthcare allows another person to invade that very sacred liberty interest that we have. It also kind of creates a contract between the provider and the patient. It's a unwritten contract where you're giving permission for someone to do something to your body, and you have an expectation that they are going to help you. So it's kind of this verbal contract that you have. But because of that, it invokes all these duties, right? We know that doctors, nurses, other providers have all kinds of duties to the patient, but underlying that is kind of this contractual agreement. Consent is a really important issue in public health. Something that we're going to continue to talk about is sometimes we have to treat those that can't consent. So where do we get that consent, and why is that important? Think about patients with dementia and Alzheimer's, patients with really important psychological needs. What about children, unconscious patients, patients with language barriers? While providers and patients try to figure out these questions, it's really up to us as public health professionals to prepare for these issues ahead of time, either through education, policy changes, laws, really. So this week we have two more cases. The first case is Smith v. Sibley. Now this is a Supreme Court of Washington State case. In this case, a doctor performs a vasectomy for Smith, and at the time of the operation, he was 18 years old. Smith later argues that the surgery was performed without valid permission. One of the interesting features of this case is, in Washington in 1967, basically, he is a minor because he's under 21. So what he's arguing is, I was not 21, therefore I could not consent to surgery, therefore the doctor should not have done it. Since he did it, I'm suing him. That's the gist of it. But you really got to read the case for a lot of the details, as well as the decision, which talks about the rule of sevens. Now don't get stuck on the rule of sevens, because that's not really the important takeaway here. The important takeaway is what is important in terms of someone being able to make their own decision. Do we follow that in all cases? Is it just with minors? Is it with the elderly? Is it with people with disabilities, right? Something to think about. I also gave you another case, Smith, in addition to Smith, which was Cardwell. Now Cardwell is the Supreme Court of Tennessee. It's a couple decades later, but this involves an osteopathic doctor who does an osteopathic treatment on a 17-year-old girl. The family later sued when she was injured, arguing that she did not have the requisite authority to give permission to the doctor to treat her because she's 17. Well, the court comes out with a very different decision than Smith v. Sibley. So why don't you just read the two and compare. There's no one takeaway from this other than these are complicated questions about healthcare decisions. In the Bechtel case, the court finds that mental capacity necessary to consent to a surgical operation is a question of fact to be determined from the circumstances of each individual case. Well, that doesn't really give us a good answer about who can consent to healthcare, or in this case, a surgical operation, or not. Cardwell's daughter in the second case is almost at the age of consent. Do bright line rules like your 18th or 21st birthday make sense? Should you really be able to say, I can consent to this one day, but the day before you cannot? aren't these ages somewhat arbitrary? Well, what else is arbitrary in healthcare decision making? We have a lot of unanswered questions, but if we read through these cases, we're given some guidelines about how to think about these. Now, as a public health professional, you need to understand why healthcare consent is important and how we use it to create policy, because really well-written healthcare policy that understands consent can create better health outcomes. So a couple of other issues. Remember we talked about the state police power. That's the power of the state to make laws about health and healthcare. There's not a lot of federal law around the age of consent because it's considered a police power and therefore it's left up to states. So think about these other situations this week. What happens if a parent or a legal guardian refuses to give permission for necessary treatment? Say a child has cancer and needs a certain treatment that the parent disagrees with. What about if a parent or a guardian is not an English speaker and the child is the translator between the parent and the provider, and the child's also the patient? What about provider who believes the child is being abused by the parent or guardian? What kind of conversation should they have? What about parent or guardians themselves that are under 18? If a mother has an infant and she's only 17, who really should be the decision maker? What happens when providers mistakenly believe someone is over 18? Should they be held accountable for that? So that's it for week 10. I've thrown a lot at you. Check out the readings. There's a couple of short YouTube videos. What the takeaway for this week really is I want you to think about why it's important to dissect who can make healthcare decisions and how you use that to make better health policy. You all should have your outlines returned and graded. Thanks and have a great week.